Good afternoon. My name is Oliver Jaberg. I'm FIFA's Deputy Chief Legal and Compliance Officer and Director of Integrity and Anti-Doping. It is my pleasure to welcome all the participants to this webinar on the new FIFA Anti-Doping Regulations 2021 edition. I would like to take this opportunity to thank you for your interest in getting yourself up to date about the upcoming changes to the legal framework enabling us to fight doping in football. As you know, the work and collaboration of associations and national anti-doping organizations together with FIFA as well as further stakeholders is key to make sure that players' health is protected and that a level playing field in football is ensured. You may also know that for this endeavor, FIFA is working in close collaboration with the World Anti-Doping Agency, WADA, and is a WADA code signatory. By becoming a signatory, FIFA agreed to accept and to implement the WADA code. The WADA code, since its inception in 2003, has been substantially revised in 2009 and in 2015. Now, the latest revision in 2021 gave need to adapt the new FIFA anti-doping regulations in order to bring it in line with the WADA code. And therefore, the goal of today's webinar is to familiarize you with these new rules. So for the next 45 minutes, the members of the FIFA anti-doping department, in particular Alexis Weber, FIFA's head of anti-doping, Monika Keller, FIFA senior anti-doping manager, and Daniel Kim, FIFA anti-doping manager, will give you an overview on the most important new definitions contained in the revised FIFA anti-doping regulations. Also, my colleagues will briefly speak about the additions to the catalogue of anti-doping rule violations and touch upon disciplinary violations as well. Equally, they will speak about how the results management process looks like once a player has tested positive for a prohibited substance. And lastly, they will address the implementation process in order to ensure that your member association's rules are compliant with the FIFA anti-doping regulations. After that, a short questions and answer session will conclude this webinar. If you would like to ask a question, please do so in writing by using the Q&A tab at the bottom of your Zoom window. We will gather those questions and will address some of them after the presentation. And now, without any further ado, I would like to invite Daniel Kim to share with you some additional introductory remarks. Daniel, please, the floor is yours.
Thank you, Oliver, and thank you what we are going to talk, for summarizing what we're going to talk about today. I would also like to welcome all of you around the world and would like to thank you for taking your time to watch our webinar regarding the new FIFA anti-doping regulations. In order for you to have the most out of this presentation, please allow me to first mention some of the housekeeping rules. You first have the possibility to follow this webinar through our translation services. We provide simultaneous translation in French and in Spanish, so if you prefer to listen to one of these languages, please navigate to the Interpretation tab at the bottom of your Zoom window and simply click on the language you would like to have. Also, as already mentioned, you have the possibility to ask questions about topics we're going to address today. As you will stay muted during this presentation, please pose your question in writing by using the Q&A button displayed in your Zoom window at the bottom. By using it, you will open a window in which you can write your questions. All the questions will be collected and addressed either in the Q&A session following this presentation or in an individual follow-up with you. Also, after each topic, we have prepared a little multiple choice question for you as a means to check your progress in understanding the new FIFA anti-doping regulations and to enhance your participation possibilities. Lastly, I would like to mention that this webinar will be recorded and will be made available to you later on FIFA's respective media channels. Also, we are going, of course, to provide you with the slides of this presentation after conclusion of this webinar. Now, in order to better follow this webinar, we advise you to have your copy of the new FIFA anti-doping regulations with you. You can access the document on the web by following the link displayed here, or click on the link included in your invitation to this webinar. Please note that from now on, when we are talking about the FIFA anti-doping regulations today, we are going to refer to them simply as the FIFA ADR or as the regulations. So as an intro into the new FIFA ADR, we're going to show you now a little video we prepared, which will give you a short overview of some of the most important matters that we're going to talk about today. Please enjoy.
FIFA's new anti-doping regulations come into force on the 1st of January 2021 and reflect the updates made to WADA's World Anti-Doping Code. These are the most important changes. More nuanced sanctioning approach. The new rules make a better distinction of players' level of professionalism. For that, 2 new categories are introduced. Protected persons, youth players who have not yet played at Confederation or World Cup level, and recreational players who do not compete at international or national level. Players in these 2 categories are subject to lowered sanctions and may be granted flexibility when making their case before an anti-doping panel. The new regulations also foresee harsher sanctions in cases with aggravated circumstances. Substance of abuse policy. If a player tests positive because of a drug problem and not for sport performance enhancement, the focus has to be on their health, on helping them get clean. If a player can prove that the use of a substance of abuse is unrelated to sporting performance, a blanket ban of 3 months will apply. This ban can be reduced to 1 month if they join a FIFA-approved rehabilitation program. Greater protection for whistleblowers. FIFA may rely on people coming forward with information about doping incidents. From now on, discouraging others from reporting doping-related behavior or threatening them for it are considered violations of the anti-doping rules. Sanctions range from a 2-year ineligibility to a lifetime ban. Strengthening procedural rights. Fair hearing principles guarantee that players can state their case according to worldwide judicial standards and ensure the maximum independence of the anti-doping panels. Education for the win. Education is a crucial element in the fight against doping, and FIFA's new regulations make a point in highlighting the importance of instructing players and support staff. Because the more everyone knows, the better we can fight doping together.
So, after this quick warm-up, I would say we dive right in and address some of our new definitions within the new FIFA ADR. So first, please allow me to talk about aggravating circumstances. Now, this term has been reintroduced in the context of the WADA code after being removed in the 2015 revision. Aggravating circumstances might be present in certain cases in which a player commits an anti-doping rule violation. Aggravating in this sense means an increase in the seriousness of the violation. So for this, the FIFA ADR foresee a longer sanction than what could be applied in generic cases. In the definition, there is a non-exhaustive list of circumstances which are to be seen as aggravating, such as using or possessing multiple prohibited substances, being caught with prohibited substances in multiple occasions, or the act of tampering during the results management or hearing process. Now, as mentioned, this list itself is non-exhaustive. So the Court of Arbitration for Sport or your respective anti-doping panel have the freedom to define further circumstances as aggravating circumstances. If such are established in an individual case, the otherwise applicable sanction can be increased above the normal sanction framework up to 2 additional years. So if you have, for example, an anabolic steroid case where intention of the player is proven and also aggravating circumstances are applicable, then the player could be potentially sanctioned for 6 years instead of the applicable 4 years in the previous regulations. Please also note that for certain other anti-doping rule violations like trafficking, administration, or complicity, this definition is not applicable. Why? Because these types of violations already foresee the possibility of a lifetime ineligibility, and therefore it makes no sense to include the examination of aggravating circumstances in this. Moving on to the new term of competition venues. Now, what exactly is a competition venue? During a FIFA World Cup, for example, every stadium, team hotel, training site, hospital, or other site which have a designated function for the FIFA World Cup would be considered a competition venue. Now, why is this important? Within the area of those competition venues, only the ruling body of that competition, so in case of the World Cup, FIFA, has the authority to do doping controls. Any other anti-doping organization, which would also have testing authority over certain players or teams, needs to contact the ruling body of that competition venue first in order to coordinate the doping controls. So if you have, for example, a national anti-doping organization in the country in which the FIFA World Cup is held, and these national anti-doping organization would like to test at a team hotel or stadium, this national anti-doping organization would need to liaise first with FIFA in order to coordinate its testing efforts. This terminology was implemented to strengthen the concept that only one testing authority can actually test a certain team. And the practical idea behind this is to avoid that teams will be tested by mistake by different anti-doping organizations at the same time. Now, moving on to the specific term of education, it reads as follows in the FIFA ADR. Education is the process of instilling values and developing behavior that foster and protect the spirit of sport, and also to prevent intentional and unintentional doping. So as mentioned in the video before, we think that proper anti-doping education is absolutely crucial in order to protect the health of all players and the integrity of football itself. It is very important to educate players, team staff, officials, and all other people involved in football about doping and its legal and health implications. It is also important that education on this topic happens on a regular basis. So that is why the FIFA ADR clearly defined education as one of the members' association's key responsibilities. We expect that members' associations develop their own anti-doping educational program and hold regular educational sessions with all their football teams. Those sessions should teach all those attending them about the negative aspects of doping, how players can seek help in case of a medical condition in which they need a particular prohibited substance, and how all people involved in a doping control process can support that particular process. So the ultimate goal is really to enable players and everyone involved in football to further support the global efforts to fight doping in football and make sure that this game we all love stays clean. Now, when we move on to the in-competition definition, please be aware that this definition has existed in the old version as well, but has undergone a major change. In the old regulation, it was clear that a player is considered out of competition until the day he or she played his first match at a certain tournament. Following the first match, the player would be regarded in competition throughout the whole tournament. Now, this is not the case anymore. What we try to illustrate on the slide here is that now in competition periods and out of competition periods are alternating themselves, even during a tournament. Now, the relevant in-competition period for a particular player or team starts exactly on 1 minute before midnight, the day before the team's match, and lasts until the completion of the sample collection process relating to that specific match. After that time period, the player or team will be considered out of competition again until the next 1 minute to midnight, the day before the next match. So you can clearly see that even during a tournament now, a player will have alternating periods in which he or she is either in competition or out of competition. And this has some important practical implications. If you have, for example, a team doctor who would decide to treat a certain inflammation with glucocorticosteroids through a prohibited route of administration, he or she could on one side be allowed to do that since glucose are only prohibited in competition. He or she, however, would create a huge risk that the player's metabolism is not able to get rid of the substance quickly enough before the next in-competition period, and also the possible next test. So if the player would then be tested positive for glucocorticosteroids, this would be considered a possible anti-doping rule violation, even though the administration happened out of competition. So this new definition should be clearly understood by all the team doctors and other individuals who are treating players or are at least included in their treatment. As the players have a strict liability as to what goes into their body, this is exactly an area where they need all the support they can get, knowledge-wise and process-wise, from all of you. Now let's move on to a slightly technical but nevertheless important new definition, as are the new terms of institutional and operational independence. They act as new requirements for anti-doping panels. By adhering to them, a fair trial and independent adjudication can be guaranteed to everyone being faced with a charge of an anti-doping rule violation. Institutional independence means that there needs to be a clear separation between individuals who are dealing with the results management process of a case and individuals who hear the defendant in a hearing and decide upon a possible sanction. It should therefore be seen as a separation on an organizational level. Operational independence, on the other hand, means that a case should not be influenced by individuals representing a member association or having conflicting duties within the member association, confederation, or even FIFA. So, as a practical example, this means that a board member, commission member, and others cannot at the same time sit in or be part of an anti-doping panel while having those other duties. This is to avoid any arising conflicts of interest and to guarantee that an anti-doping panel can reach a decision without being influenced from the outside. Also, a new and important addition are the terms of protected persons and recreational players. Now, these kinds of players need to be distinguished from other professional players. On one hand, with protected persons, we are talking about minor or very young and inexperienced players being especially vulnerable during the anti-doping process. The FIFA ADR take into account the fact that they are just at the start of their career and foresee certain mechanisms which make it easier for a protected person to state his or her defense in the event of an anti-doping rule violation, and also to enjoy certain limits of publicity. Now, please note that this does not include 16 and 70-year-old elite players who have already competed internationally, because those players will be treated like regular professional players to ensure equal treatment of players at the highest level. Another important addition is the introduction of recreational players. Those are semi- or non-professional players playing football as a hobby and in lower tier leagues. Now, please be aware that this definition might differ from country to country because the relevant national anti-doping organization in your country has the final authority to define who will be seen as a recreational player. Now, the consequences of a particular player being either protected person or a recreational player are almost the same. They first do not need to establish how a prohibited substance entered their body in order to contest a no-fault negligence or a non-significant fault negligence dispute. Furthermore, the possible range of sanction is fixed to either a minimum of a reprimand or a maximum of a 2-year ban. And lastly, the public disclosure of sanctions involving these kinds of players is not mandatory. Now, the last really important definition I want to talk with you today is the substance of abuse definition. There are certain prohibited substances which are far more likely to be abused in the outside of sport context. Sometimes we would also refer to them as social drugs. Now, at this point, we expect that WADA will publish the new prohibited list of 2021 in about exactly 1 week, including the information which substances are to be considered substances of abuse. We already have some hints as what might end up on that list, so there is strong indications that cocaine, cannabinoids, MDMA, or as it is commonly referred to as ecstasy, and also heroin might end up on the substance of abuse list. Now, what happens when a player has been tested positive for a substance of abuse? So if the player can prove that he or she took or used the substance of abuse out of competition, perhaps at a party with friends, and that this use was unrelated to sport performance, and that it also had no performance-enhancing effect, then he or she will only receive a ban for 3 months. Also, if there are indications that the use of the substance was due to a drug problem, there is the possibility to refer that player into a rehabilitation program. Successful completion of such program will be rewarded with a further reduction of the ban down to 1 month. Now, FIFA is still in the process of establishing how to evaluate those programs, but we can say that there is the possibility to approve such rehab program retroactively, and that the player does not need to wait for FIFA's approval to enter into such a program. We will certainly be able to give you more information in due course as to how exactly to implement this feature. Now, what happens before these new substance of abuse rules come into force? What if you have a player having tested positive for cocaine just this month, and you want to impose a 2-year ban on him because of the facts to the case? There we clearly state that until 31st of December of this year, every case needs to be treated as has been in the past, so according to the rules that are currently in place. So if it is justified to impose a 2-year ban on that player, you are able to do so. Please note, however, that the WADA code foresees certain mechanisms for the transition period from the old rules to the new ones. In particular, the code foresees the possibility for the players who have been sanctioned for possible abuse substances according to the old rules, that they can, starting from 1st of January 2021, file an application before the Results Management Authority, which was responsible for handling his or her case, and demand a consideration of a reduction of his or her ban. Now the moment has come for you to participate a first time in this webinar. You will soon see a window pop up in your Zoom application in which you have the possibility to select a correct answer. So what we would like to know at this instance is, in which of the following scenarios is the player to be considered in competition under the new FIFA anti-doping regulation? Is it A, a training session 1 day after a match? Is it B, on the way to the stadium on match day? Or is it C, press conference after sample collection? You have now 30 seconds to enter your answer, and don't be afraid, it will be anonymously. It's just about you checking your progress and understanding the FIFA ADR. Okay, the polls will be closing now, and in a few seconds you should be able to see the results. And I already got the sign from my colleagues that most of you have given the correct answer. It is, of course, answer B, on the way to the stadium on match day, because I would like to remind you here, the new in competition period starts 1 minute before midnight, the day before the match, and goes on until the sample collection process related to that match. So thank you very much for your participation. And it is now my pleasure to hand over to Alexis, who will talk about the anti-doping rule violations and disciplinary measures within the FIFA ADR. Please, Alexis.
Thank you, Daniel. Okay, before we tackle the result management process of a positive case, we will have a look at the different anti-doping rule violations and disciplinary measures. Within the FIFA anti-doping regulations, the different anti-doping rule violations are listed under Article 6 till 16. This includes, amongst others, whereabouts failure, tampering with the doping control process, as well as trafficking prohibited substances. These articles are a copy-paste from the WADA code. On the other hand, disciplinary measures are according to the FIFA disciplinary code and usually ends with the wording may result in a disciplinary measure in the respective article of the FIFA anti-doping regulations. This includes, for example, an inappropriate behavior against a doping control officer. So let's have a closer look at the possible consequences of an anti-doping rule violation. The player may be sanctioned with a period of ineligibility up to 4 years. And as we just heard before, if aggravative circumstances are present, even with 6 years. When we compare this with the consequences applied by the first World Anti-Doping Code from 2003, this is an increase of 3 times the maximum sanction, as at that time the maximum time for ineligibility for anti-doping rule violation was 2 years. Further consequences will be for a player that his or her individual results will be disqualified, and there might be some financial consequences as well. On top of that, the anti-doping rule violations needs to be publicly disclosed as defined by the regulations. So keeping in mind the anti-doping rule regulations are not only applicable for players, they also concern player support personnel, football officials, coaches, managers, and so on. This has been better clarified in the 2021 regulations. There are clear indications who can commit a specific violation. So let's have a look at some examples. Article 6, presence of a prohibited substance or its metabolites or markers in a player sample. This article is obviously only applicable for players. On the other hand, Article 10, as an example, tampering or attempted tampering with any part of the doping control is applicable for everyone. The player as well as any other person who violates the process. Next, we have a look at a new article integrated in the FIFA anti-doping regulations, Article 16. It defines, I'm going to read, acts by a player or other person to discourage or retaliate against reporting to authorities as an anti-doping rule violation. Notice when we looking at this article that again anyone can commit this anti-doping rule violation, as in it mentions player and other persons. The violating conduct would be every act of discouraging by a person which lacks good faith and which has to be considered disproportionate in the relevant context. So in other words, the action towards the player or person reporting something needs to be seen threatening or intimidating. The range of possible recipients of such report is very wide. The article mentions the World Anti-Doping Agency, FIFA, and other national anti-doping organizations, but also reporting before governmental authorities or law enforcement is protected. The same consequences apply if a report has already been filed and if a person is retaliating against the one who filed the report. As a consequence, the violating person would face a period of ineligibility, starting from 2 years up to a lifetime ban. Everything would be based on the seriousness of the violation. The intent behind this article is to better protect whistleblowers in order for them to come forward with information that could lead to the potential cover-up of doping. Recent outspoken whistleblowers have been proven to be very valuable in the fight against doping. And therefore, at this point, when we speak about whistleblowing, I would like to point out that many years ago, FIFA has introduced its own whistleblowing platform on which everyone can report possible doping infringement in an anonymized and confidential fashion. As it is a vital tool for gathering information, we would encourage you to check this tool out by yourself, following the link displayed on the slide, or you can also find it on legal.fifa.com under the anti-doping tab. Furthermore, we encourage you to spread the word within your organization, including a link on your webpage to enable your members to contribute to a clean sport. Now let's have a closer look at the potential disciplinary violations within the FIFA anti-doping regulations. Most of the disciplinary violations are addressed in Article 3, Paragraph 5 of the FIFA ADR. For example, failure to cooperate during an anti-doping rule violations investigation. This concerns the moment from which the result management process is initiated. This also includes cases in which the individual person might not be involved in. Another example would be a possible offensive conduct towards a doping control officer. So, for example, if a player or team representative verbally attacks a doping control officer, this would lead to a possible disciplinary measure. Important to note here again that every person can commit these sorts of violation. It is not just limited to the players as a possible offender. Lastly, the use of prohibited substances, methods by anyone other than a player, so excluding the player, for example, team doctors and coaches, without valid justification can also lead to disciplinary violations. These are additional measures taken to reassure that no prohibited substances are within the premises of the sport. So all the sanctions are according to the FIFA disciplinary code, which may involve a warning, a fine, or a ban from taking part in any football activity. And this brings us already to the next polling questions. So you see up on your screen the next question. It's, what is the main intention behind the new Article 16, discourage and retaliation? Is it A, safeguard players' health, B, better coordinate between anti-doping organizations, or C, protection of whistleblowers? So you may submit now your answers, and gonna leave the poll open for another couple of seconds. Okay, we're gonna close the poll now, and the correct answer should pop up on your screen. Yeah, and it is answer C, and most of you had it correct, so thank you very much for paying attention. And I will hand back the floor to Daniel, who will talk about the result management process.
Thank you again, Alexis. So this part deals with the administrative process after a player has tested positive. We will have a quick look at some of the most important aspects and talk about what is needed to guarantee the right to a fair hearing for a person being charged with an anti-doping rule violation. So although it is a legal topic, we also hope that the non-legal audience will bear with us, as it might be also important for you to know how this process is set up. As mentioned, the whole process is called results management. When looking at the FIFA ADR, especially the new articles 52 to 60 deal with the results management process. We display you here on the slide the results management definition, and you can see that it encompasses all the steps from the moment the player is notified about a possible anti-doping rule violation up until the issue is decided in front of an anti-doping panel. So what I would like to highlight in the next minutes are some of the key steps and essential notifications that players or other persons within your association should receive in order for the results management process to be called fair. So once a player has been tested positive for a prohibited substance or received an adverse analytical finding, as it is called technically, the relevant entity in charge of investigating the matter should first conduct initial review. This is to rule out that the presence of the prohibited substance might be somehow justified, maybe because of a therapeutic use exemption or because it was administered through an allowed route of administration. Now, once the initial review has been concluded, the player and the association should be provided with a notification letter as referenced in Article 53, paragraph 5. This letter is key as it informs the player of a positive testing result. Also, it should give the player the opportunity to ask for the analysis of the B sample. Now, such analysis of the B sample can be requested by the player either 12 hours after notification, namely when the sample was taken in competition, or 48 hours after receipt of the notification when the sample was taken out of competition. Now, please be aware that also the entity conducting the results management can request the B sample analysis. So if FIFA has been the sample collection authority and testing authority, it could also be FIFA who could request the B sample analysis. Now, the player should be invited to attend the opening of the B sample at the laboratory, and the results management authority should inform the player and also you as the association about the identity of an independent witness in case either the player or the player's representative cannot be present at the opening of the B sample. Now, after the necessary analysis have been done, the second and most important piece of information you should pay attention to is the what we call B sample letter, informing the player about the outcome of the B sample analysis. In there, the player should also be provided the opportunity to give a short explanation or to admit the violation right away. Also here, the FIFA ADR clearly lists all the requirements of what this letter needs to entail under Article 54 of the FIFA ADR. At the completion of this stage, the investigation will be concluded, and the investigation entity will hand over the case file to the competent anti-doping panel within your country to decide the case. The most important part in this adjudication process is that the player is provided with the so-called letter of charge. Now, this is a centerpiece of information and should provide the basis in order to protect the player's right to be heard. So we kindly advise you to study the new Article 58 of the FIFA ADR extensively to see what a letter of charge needs to include to respect that right to be heard. Whenever the content of the letter of charge deviates from what is stated in Article 58, then the whole process might become flawed, and any sanction pronounced on top might get overturned by the following appeal instances. So with this quick excursus over the results management process, we of course also have a question for you this time. This time we would like to know from you, what is the most important element in the adjudicatory process to safeguard the player's right to be heard? Is it A, the doping control form? Is it B, the letter of charge? Or is it C, the information about when the B sample is analyzed? Once again, I'd like to invite you to enter your answer, and then we'll have a look at the results. All right, polls will be closing now. And also this time, I see the majority of you have voted correctly. It is, of course, the answer B, the letter of charge, the centerpiece of the adjudication process in order to adhere to the player's right to be heard. Now, I will hand over one last time to Alexis, who will talk about the implementation possibilities of the FIFA ADR rules into your own legal framework.
Good. So to guarantee an equal playing level field in football, it is essential that each member association incorporates the FIFA anti-doping regulation to reassure the same rules apply everywhere where football is played. Furthermore, FIFA, as a WADA code signatory, has the responsibility to ensure that every member is compliant with the rules of the International Federation, which itself has to follow the rules of the WADA code. Therefore, it is crucial that the rules from the WADA code trickle down to the very latest puzzle piece in football. Otherwise, FIFA football would be declared as non-compliant by the World Anti-Doping Agency. There are two different possibilities to incorporate the FIFA anti-doping regulations. One possibility is for direct adoption of the FIFA anti-doping rules into your own set of regulations. You as a member association will create your own regulations or adapt the wording of the FIFA anti-doping regulations to become the basis for it. If you choose this option, we recommend you insert the following article in your regulations, and I'm going to read it. In the event of any discrepancies between the national regulations and the FIFA anti-doping regulations, the provisions set out in the FIFA anti-doping regulations shall prevail. The other option to incorporate the FIFA anti-doping regulation is by reference. You as a member association can just simply include a provision in your statutes and or in the relevant regulations referring to the FIFA anti-doping regulations. If you choose this option, we recommend that you use the following wording. In doping-related matters, the FIFA anti-doping regulations apply in full. In the event of any discrepancies between the national regulations and the FIFA anti-doping regulations, the provisions set out in the FIFA anti-doping regulations shall prevail. So in terms of organization and making sure that you are compliant, this is certainly an easier option to go for. Also, you would not be required to update your regulations every single time when the FIFA anti-doping regulations are amended. In order to be able to see what choice you made regarding the implementation, we ask you to send us either your own updated anti-doping regulations, or if you choose to implement the FIFA anti-doping regulations by reference, the applicable documents referencing the FIFA anti-doping regulations. This is in order for us to examine that you as a member associations are compliant with the rules of the World Anti-Doping Code. The deadline for this is set by 30th November 2020. If you have any questions, just send us an email to antidoping@fifa.org, and we will get back to you in due course. Already at this point, we thank you for your collaboration, and this actually brings us to the end of the presentation. We will now start the Q&A session, and for this we quickly change the presentation to see the slides where the questions are gathered by Monica, and she will also guide us through the Q&A session. So, Monica.
Thank you, Alexis, and thank you, dear participants, for sending in interesting questions. I have collected them, and Daniel, I would like to ask you the first question. What is the minimum content of a decision?
Thank you, Monica. So I'm quickly gonna pull up my new ADRs because I can give you the answer right ahead. For this, you can actually turn to Article 63 of the regulations. Therein, the paragraph 1 lists basically all the requirements that need to be entailed in a decision. Some of the most important points, I think, are reasons for the decision, of course, then the detailed factual background, the applicable consequences, so if you impose a period of ineligibility, and also if you don't impose the maximum of a potential consequence, a justification on why you did not so. So Article 63 is a really good piece of guidance for you as what needs to be in a decision.
Thank you, Daniel. Alexis, the next question for you. What are the criteria to become a member of a hearing panel?
What are the criteria to become a member of a hearing panel? There are no criteria or list of criteria set out in the FIFA anti-doping regulations. But in the international standards for result management by WADA, it defines so they need to have the relevant expertise and also undergoing continuous education. And one of the panel member needs to have a legal background. But what we touched on before during Daniel's presentation, there are certain criteria that exclude you to become a member of a hearing panel to guarantee operational independence. And this would be that there's no conflict of interest and you would not be allowed to be an administrator or a commission member of an anti-doping organization. Yeah.
Thank you. Daniel, the next question for you. Can you give an example of an inappropriate behavior against a doping control officer?
Thank you, Monica. Well, I think what we have to differentiate here first is if this inappropriate behavior would actually interfere with the doping control process itself. Because as you might remember that we also have an anti-doping rule violation called tampering with the doping control process. So if it would amount to such an extent that the doping control process itself would be tampered with, then you would certainly need to pull that into, sanction that according to the anti-doping rule violation catalog. If it's just a disciplinary violation, then of course I could give you an example. It would be, for example, offensive language towards the doping control officer. But if a player would, for example, leave a doping control without the consent of the doping control officer, I think this would be a much more serious issue to look into than just being inappropriate behavior. So I hope this differentiation might give you some guidance already.
Thank you, Daniel. Alexis, another question for you. How should we do doping controls, or how should we support testing? Can you give advice?
If I understand the question correct, how should we do doping controls? Everything starts with a risk assessment, that you assess the situation within your country, and then you set your priorities. You try to identify the target groups where there is some incentives to cheat, and then you go one step further and do your test distribution plan. So you go through, you make a plan for the whole year cycle, which is obviously a working document. You amend it from time to time. And then it goes to the next step to actually implement the tests. You select the players for target testing if there is some evidence of abnormal behaviors, or you, in the end, you could also randomly collect or identify which player should be chosen to undergo the control. So that's basically, you start with the risk assessment, do the test distribution plan, identify the players to be tested, you conduct the tests, but you revise and review your documents on a timely basis to make sure that you don't miss anything.
Thank you, Alexis. Daniel, do we still need to send decisions in order for FIFA to have them extended worldwide?
Yes, please do so. I think we have in Article 74, of course, we state that all the decisions that are being rendered should automatically be binding and also respected by all the members' associations, but nevertheless, it also comes down, as we have an obligation to monitor all the ongoing anti-doping cases within our members' associations to really see if they are in line with the FIFA anti-doping regulations. So, of course, we would like you to send us your decisions as well, because it also needs to respect FIFA's right to appeal if a possible sanction is not in line with the anti-doping regulations of FIFA.
Thank you, Daniel. Alexis, the next question. Where is the B sample stored?
Yeah, the B sample is stored at the laboratory, but let's go one step back. So the A and the B samples are collected at the same time in two different bottles for urine or tubes for blood. Then they will be shipped to the laboratory, and the A sample will be analyzed, and the B samples will not be touched. But then they will be the remaining urine, which hasn't been used for analysis, will be stored together with the B sample at the laboratory. And if it results, the A sample analysis results in an adverse analytical finding, then, as we heard before, the player has the right that his B samples will be analyzed. He also has the right to witness the whole process. So he can go to the lab and see how the fully intact bottle, which can only be opened if they destroy the bottle, is open to reassure that the the players' rights have not been violated. So the B sample is stored at the laboratory.
Thank you, Alexis. Another question for you, Daniel. If a player admits an anti-doping rule violation, how far can you reduce his ban to play football?
So a reduction of a ban can occur in various ways. So you would have one possibility would be an admission of a player, but there you would need also to distinguish what is the kind of violation you're dealing with. Because if you have a very serious violation which would, or a conduct which would violate a paragraph which is sanctioned from 4 years upwards to a lifetime ineligibility, you could actually have the possibility to conclude a results management agreement, and there you can reduce the player's sanction or the violating person's sanction by 1 year. If you have just a voluntary admission of a violation which happens before the sample collection or before receiving notice, and there is no other evidence that would point towards a possible anti-doping rule violation, you can also reduce that specific sanction down to a half of the otherwise applicable sanction. And I think the last possibility you would have is a case resolution agreement in which you, together with the acknowledgement and also approval of FIFA and WADA, would propose a certain sanction, which is then also from the player is also agreed to. After being confronted by FIFA with the violation, you could also cut down at least half of the applicable period of ineligibility at this stage.
Thank you, Daniel. And the last question within this webinar for you, Alexis. The World Anti-Doping Code comes together with the international standard. Do we, as a confederation, need to publish our own international standard, but accordingly with the international standard from WADA? Or will FIFA publish and the confederation will follow the FIFA's international standard?
No, you don't have to publish your international standards. So the WADA code comes with 6 different international standards, one also the international standards for laboratories. So what we did or expect from you first is we would recommend that you, as mentioned before, just by reference, include FIFA anti-doping regulations in your statutes or the relevant regulations. Within the FIFA anti-doping regulations, we incorporated the most important paragraphs from the international standards which are applicable for football. And if there is further clarification needed within our FIFA anti-doping regulations, we have a reference to the WADA code and so for the international standards as well. So no need to publish your international standards.
Thank you, Alexis. And now I would like to hand over to Oliver Jabak for the closing remarks.
Thank you, Monica. And thank you all for attending this webinar, and in particular also for providing these interesting questions, which makes that webinar interactive. So we hope that you were able to get a closer look and a more detailed idea of what is coming in 2021 in the anti-doping world. We are extremely grateful to be able to count on each and every one of you as our allies in our joint efforts and fight against doping in football and in making sure that clean sport wins. We therefore also welcome every feedback from your side and will be pleased to support you in your ongoing anti-doping efforts. And in this regard, I would also like to recall that you will find additional information on FIFA's activities in the field of anti-doping on our webpage legal.fifa.com. So thank you very much again. Play clean, stay healthy, and we look forward to meeting you in person, hopefully sometime soon. Bye-bye.